Today I'm here to affirm the resolution resolved. Plea bargaining ought to be abolished in the United States criminal justice system. For sake of clarification, I'd like to offer the following key definition. Plea bargaining, the process whereby the accused and the prosecutor in a criminal case work out a disposition of the case subject to court approval. It usually involves the defendants pleading guilty to a lesser offense or to only one or some of the counts of a multi-count indictment and in return not often for a lesser sentence than that possible for the graver charge. Black's Law Dictionary. Ought, auxiliary verb used to indicate duty or correctness. My value for today is public safety, which is defined as the welfare and protection of the general public. Usually expressed as a governmental responsibility, most states have departments whose primary goal is the prevention and protection of the public from dangers affecting safety such as crime or disasters. By allowing plea bargaining to remain in the United States criminal justice system, we are allowing the system that is meant to protect citizens and to preserve their rights and to prosecute criminals fall short of its objective, and we are allowing citizens to lose their trust in what is meant to protect order, therefore impairing the public safety of the general citizen. The method by which my core value be achieved and weighed is my value criterion of retributive justice, which is defined as a form of justice committed to the following three principles. 1. That those who commit certain kinds of wrongful acts, pragmatically serious crimes, morally deserve to suffer proportionate punishment. 2. That it is intrinsically morally good, good without reference to any other sort of goods that may arise, if a legitimate punisher gives them the punishment that they deserve. And 3. That it is morally impermissible intentionally to punish the innocent or to inflict disproportionately large punishments on wrongdoers. Plea bargaining allows people to get away with being charged for less than what they did or possibly get charged unduly. Naturally, this means that the punishment no longer fits the actual crime. According to the principles of retributive justice, this should not be permitted, as people should be punished according to the crimes that they have committed. Contention 1. Plea bargaining allows for 2 light sentences. At its core, plea bargaining completely undermines the value of retributive justice as the way that pleas are bargained for is most commonly comprised of reducing a criminal's possible sentence. This becomes a real issue if one considers the fact that 95% of all convictions in the United States are secured with a guilty plea, usually through plea bargaining. What this means then is that 95% of all criminal cases are concluded with a guilty plea in exchange for some kind of benefit towards the accused, often treating offenders charged with serious crimes as if they had committed only a minor infraction. One example of this was in 2014, Minnesota Vikings running back Adrian Peterson agreed to a plea bargain which reduces felony child abuse charges to a single charge of reckless assault, a misdemeanor that comes with a $4,000 fine in order to perform community service. In general, common benefits for the defendant in regards to plea bargaining include what is referred to as reduced anxiety, avoiding incarceration, lesser charges, reduced sentence, and avoiding publicity. While arguments can be made that some of these exchanges are warranted, the crux of the matter is that defendants ought to proceed to trial in which just punishment will be meted out and observed. Such reductions only lead to criminals lacking respect for the justice system, as will soon be addressed, and families not receiving proper closure. Contention 2. Devalues the justice system. The use of plea bargaining in the United States criminal justice system runs the real risk of devaluing the justice system in the eyes of criminals and ordinary citizens alike. According to the Marquis Law Review, quote, deterrence, of course, further weakened as the criminal brags about his deal and spreads word throughout the community that the law has no tooth, end quote. The Marquis Law Review further argues that plea bargaining teaches the criminal that judges and lawyers can ignore the law when it is expedient to do so. With the knowledge that after being caught for a crime, they can simply plead guilty and receive a reduced sentencing, much of the respect for the law in question is removed in the eyes of the criminal. Additionally, there is some cause for concern among the general public as well. As plea bargaining takes place in private and is not open to public scrutiny, the public is often suspicious of the process, which has led to a decline in public confidence in the justice system. If the public cannot trust that justice is being properly meted out, then the safety of the public is compromised by their lack of faith in the institutions which are meant to protect them. As Fine put it, quote, plea bargaining is a blot on our criminal justice system. It encourages crime and demoralizes victims in society. Abolition will restore a long-absent respect for the criminal justice system. Contention 3. Promotes undue case settlements. A research study conducted by Bar, Grill, and Gazal for the American Law and Economics Association argues, quote, that the breadth of the prosecutor's discretion in negotiating plea bargains directly affects the magnitude of the innocence problem. In this case, unfettered discretion translates into more plea bargains, including more plea bargains accepted by innocent defendants. This supports the concern that prosecutors, in a desire to settle the case and earn a conviction, work more to secure guilty pleas than to secure justice for victimized families. In turn, the President's Commission and law enforcement stated, quote, there are also real dangers that excessive rewards will be offered to induce pleas or that prosecutors will threaten to seek a harsh sentence if the defendant does not plead guilty. In a system that focuses on the ability to make a deal, the facts and details of what actually happened and the legal consequences for those actions become less important. This can lead to sloppy or incomplete investigations by the police and prosecutor and poorly prepared cases by defense attorneys. This seeking of prosecutors for guilty pleas then also raises the issue of pressure on innocent defendants as well. To quote Josh Bowers, plea prices start high and prosecutors permit little if any negotiation. Duress and coercion become real worries, not just for innocent defendants, but for all defendants. One example of this pressure manifesting was the case of Ada Joanne Taylor. Taylor was accused of murder in 1989 and was told that she could either plead guilty or be awarded with a 10 to 40-year sentence and go to trial, where found guilty, face a life sentence. Taylor took the plea deal and served 19 years in prison before being exonerated after DNA testing. A case study conducted by Lucian E. Durbin and Vanessa Adkins with college students found that when presented with similar options to get out of nega scenario, innocents will almost always falsely admit guilt in return for a beneficial sentence. The affirmative is not attempting to imply that all prosecutors and all defendants are experiencing this phenomenon, but that they occur enough that it is a concern which should be rectified by affirming the resolution. And I now yield to cross-examination.
All right. Is my opponent ready?
Yes.
Let me just get my timer. Then I shall begin. Okay, firstly, your core value is public safety, correct?
Yes.
All right, and your value criterion was retributive justice.
Yes.
Your second point in that was it is something is good if it was enacted by a legitimate punisher, correct? A punishment is?
Yes, specifically that it is intrinsically morally good
Okay.
and some legitimate punishment is punishment deserved.
You're characterizing the criminal justice system as a legitimate punisher.
Yes.
Okay. How can you justify that when arguing that it is currently a corrupt system in which both the prosecutors, the judges, and the defendants all engage in corrupt actions in the process of plea bargaining?
Well, when we're talking about plea bargaining, we're talking about affirming a resolution which will achieve the values of retributive justice.
Okay. So your third contention, you talked about more people accepting plea bargains as innocent individuals, correct? Okay, your second contention was that it devalues the criminal justice system. This is more of a social problems contention. It's about how the public sees it and how other criminals see the criminal justice system.
Yeah, well, so it deals with both public opinion and also the worry that with this public opinion that the institution is not able to protect as it should.
Okay, so you're saying that because of plea bargains, the criminal justice system is not exercising its true purpose.
It's been shown that as a result of plea bargainings, the criminal justice system has been devalued in the eyes of both who it's meant to protect and those who it is meant to prosecute.
Okay, so those who see it as an illegitimate organization.
Yes.
Okay, in your first contention, you talked about Peterson v. Texas, I think. Do you have any other examples that don't involve a celebrity?
That don't involve a celebrity? Well, the thing is that when we're talking about, are you talking about an example of someone's charge being reduced?
Yes.
Okay, so one moment. There was an example from the Justice Powell with the Supreme Court case in Marbury versus Johnson, which essentially determined that scrupulous fairness for plea prosecutors during plea negotiations relied on treatises. So what happened is that in these cases, people's sentences were being reduced, and it was determined in this case that it is fair. The affirmative is trying to argue that we cannot actually
So
reduce
what were the
sentences
specifics of that case? Because I've heard of this case before, and I don't believe it was about reduced sentences.
It was about specifically the Supreme Court case with the scrupulous. Oh wait, sorry, wrong example. Apologies. So I don't have a specific example with the specific names. There was an example in Tennessee in which two men who had committed drunk driving were able to, as a result of plea bargaining, reduce their sentences, even though they had not only been charged with drunk driving before, but their sentences had also been previously reduced before as well.
Okay, and so I think that's all the questions I have for you, actually.
Okay.
Thank you. Just as a brief roadmap, first I will be reading my constructive and then going on to attack my opponent's case. Is my opponent ready?
Yes.
Then I shall begin. I stand before you in firm negation of the resolve that plea bargaining ought to be abolished in the United States criminal justice system. For clarity, I would like to define the following term. Plea bargaining was defined in Florida v. Kennedy as an agreement between the prosecutor and the defendant which is approved by the court. The value of security, which resonates most with this resolution, supports the negation of the resolved. This principle contends that societal establishments, the criminal justice system included, have an obligation to protect the capability of citizens of the United States to achieve their fundamental rights of life, liberty, and the pursuit of happiness. This value is achieved through the value criterion of pragmatism, which stresses the importance of the viability and the feasibility of actions to achieve some type of beneficial result or goal. Working in tandem, these two principles make it imperative for the criminal justice system to seek the highest level of security for the public in a way that is feasible and allows the criminal justice system to progress smoothly. The preservation of the plea bargain in at least some capacity is essential to achieve the most pragmatic approach to guaranteed American security. My first contention is that completely removing the plea bargain would be a detriment to the efficiency of the criminal justice system, impairing its ability to achieve security. Firstly, the use of plea bargaining encourages the criminal justice system to address cases which pose a true threat to the security of the American public. As identified in Paul Burgum's Criminal Law Handbook, quote, as those offenders who are less likely to do much jail time negotiate plea bargains, the less frequently serious offenders will be let go before their full sentence has been served, unquote. In the district courts of Wisconsin, it is common for young convicts who intentionally cause damage to a vehicle which is not in their possession to plead guilty to a charge of joyriding, which is a misdemeanor, instead of receiving the full charge for operating a vehicle without the owner's consent, which is a 2-year felony. The National Insurance Crime Bureau found no increase in car robberies in the corresponding areas as a result of this practice. Instead of Wisconsin courts using their resources to take these young individuals to trial, their funds and time are liberated for use in the thorough address of more dangerous criminals. More universally, the abolition of plea bargaining has proven to be realistically crippling for the criminal justice system. In the Bronx, when plea bargaining was abolished in 1992, the backlog of pending cases increased by 24%, and defendants remain in custody for an average 40 days longer than if they would have accepted a plea bargain. The University of Southern California Gould School of Law found that the abolition of the plea bargain would increase judiciary resource usage by almost 50%. Even further, many areas, including El Paso, Texas, have regulations that guarantee that the defendant, after receiving their sentence, may have it reassessed by a judge and a jury, even if that sentence was by a plea bargain. There are various checks, including those above, that ensure that plea bargaining is fair for defendants and for citizens of the community. Security is protected, therefore, in a way that is pragmatic, allowing cases to be addressed in a time-efficient manner while still ensuring the criminal justice system can exercise its purpose. My second contention is that the benefits of retaining the process of plea bargaining far outweigh any potential consequences. One example of this is U.S. v. Kaczynski. Ted Kaczynski, in the 18 years he evaded the FBI, was able to kill 3 people and wound 23. The evidence against Kaczynski was solid enough to conduct a trial, but according to those engaged in the case, a trial would have been utterly risible. He prohibited his lawyer from citing mental illness as the cause of his crimes, and he insisted on highlighting the political message behind his killings. The claims the defense would have been forced to use in the trial were so outlandish that commentators like Susan Ferrano were motivated to say that, quote, the trial would have likely become a circus, unquote. Kaczynski, who pled guilty, received 4 life sentences and 23 years in prison. Judge, in preserving the concept of a plea bargain, cases like these are able to be addressed succinctly while still preserving American security. Though not all cases require a plea bargain, cases like these are an example of why it is beneficial to leave many options for the criminal justice system to use in its protection of our citizenry. Furthermore, plea bargains lead to the collection of information to protect the general public. For example, in 2005, Eric Rudolph, a convict of an Olympic bombing, pled guilty to avoid the death penalty on the condition that he would disclose various other locations of explosives. 250 pounds of dynamite were recovered as a result of this plea. More commonly, those convicted because of possession of narcotics are given the chance to accept a plea bargain in exchange for valuable information about higher-level suppliers. Under the strict, verbatim sentences that would be imposed without plea bargains, defendants would never concede information, like in the cases above, that would protect American citizens' lives. In cases such as these, security is directly preserved, which helps our state as a whole. Without the plea bargain, even if it were reformed, none of these benefits would be protected. Clearly, retaining plea bargaining in some respect in the criminal justice system is the most pragmatic way to ensure security for the American public. In an attempt to validate the affirmative side of the resolve, my opponent introduced the core value of public safety, which she defined as protection of safety for the general public. As I talked about in my case, we can only protect the general public by allowing the criminal justice system to exercise its true purpose in a way that will allow it to be pragmatic. If we introduce plea bargaining, as I brought up in the example of the Bronx, we will cripple the criminal justice system and not allow it to exercise its purpose at all. Having cases flow through in a way that, as I talked about in my second contention, are often very proportional, are often still just sentences, allows us to protect public safety while still allowing the criminal justice system to progress smoothly. If we abolish the plea bargain, this would not be the case. My opponent's value criterion was that of retributive justice. It involves 3 points. The first was that those who've done something wrong should morally suffer. As I talked about in my case, under the current system, under the criminal justice system, we allow those who have committed a crime to be prosecuted, and that could be through a punishment that is lesser. The punishments that we've decided in our society are decided by the society as a whole. There's no moral standard that is objective in the universe that we're holding ourselves to. We're holding ourselves to the moral obligations of our society. The second is that it would be good if it was conducted by a legitimate punisher. Again, as citizens, we validate that the criminal justice system of the United States, we have an obligation to make it legitimate. And by preserving its ability to function, we are affirming its legitimacy. And third, the punishments should be proportional. Again, in the case of U.S. v. Kaczynski, He received 4 life sentences and 23 years in prison. He will never again walk in American society. This is a proportional punishment. My opponent's first contention was that 2 light sentences are often the case with plea bargains. She brought up the case of Peterson v. Texas, and when pressed further, she brought up a case in Tennessee. Again, cases like these, as I mentioned in my first contention, are often so that courts can address cases which are more imperative to the security of the American public. Through using plea bargains, we actually protect public safety by addressing cases that are more of a threat. Again, the cases involving celebrities like Peterson v. Texas are often a problem with publicity, and that this is a reason to use a plea bargain to reduce the publicity. My opponent's second contention was that it devalues the criminal justice system. In this contention, my opponent talks a lot about how plea bargaining is kind of painted in a shady practice, and she talks about how criminals brag about their light sentences and how the public is constantly under suspicion. Again, this can be solved by shedding light on plea bargaining, and even further, in many lower courts in the United States often evaluate plea bargains and require prosecutors to create judicial records so that plea bargains can be reviewed. In this aspect, we can ensure that these plea bargains are able to be accessed by members of the community so that more light can be shed on them, and so that judges and even juries, as I mentioned in my first contention, can review these and make sure that they're not illegitimate, therefore negating the devaluation of the criminal justice system. My opponent's third contention was that there were undue case settlements. She said that more pleas were accepted by innocent people. While this may be the case, by encouraging prosecutors to engage in plea bargains where sufficient evidence ensures that defendants have a high probability of being guilty, the criminal justice system will eliminate the number of low conviction probability cases, which, as the Journal of Law and Economics finds, are those cases where exonerees who accepted plea bargains the most do come from. By using this system, we can ensure that the cases, by not using for a plea bargain for all cases, we can ensure that those cases that are not up to standards for a plea bargain, where the defendant may very well be innocent, these cases can be reviewed by a jury, first and foremost. Again, she talked about an example of the Taylor case where someone was exonerated. Again, if this case were to be one of the ones addressed by a jury under a system where we use the plea bargain efficiently, then we'll be able to address this aspect of it. These reasons, the negation stands on the clear moral high ground. Thank you. I now stand ready for cross-examination.
Gavin Austin, please report to room 403. Gavin Austin to room 403, please.
Judge ready?
Yes.
Opponent ready?
Yeah.
Then I shall begin. So you value security, is this correct?
Yes.
And you argue that plea bargaining must be maintained so we can protect the capability of the criminal justice system to fulfill its capacity.
This is because the criminal justice system would not be able to exercise its ability to secure security for the United States if it were completely crippled by the abolition.
So you believe plea bargaining is necessary to maintain the capability of the criminal justice system?
Yes.
Okay. And your criterion is pragmatism, is this correct? Specifically that we must make sure that the viability and the feasibility is upheld with the criminal justice system.
Yes.
So again, this relates to the fact that plea bargaining, if it was removed, would violate pragmatism.
That's exactly it.
Okay. And your first contention is that removal would be detriment to efficiency. You cited the backlog in the Bronx and the backlog in the Bronx. When the Bronx got rid of plea bargaining, they experienced this backlog. Did they replace plea bargaining with a more efficient system?
I think this was just a jury trial system that they replaced it with. But again, this is...
So it's just the removal of plea bargaining in this case?
Yes.
All right, and you cited South California law to, can you mention your example when you mentioned South California Law Institute?
Yes, the Gould School of Law found that that the abolition of the plea bargain would increase judiciary resource usage by 50%.
And when they were evaluating this increase in judiciary resource, were they just looking at a complete abolishment of plea bargaining, or were they looking at abolishment of plea bargaining and the replacement with a different system?
The abolition of the plea bargain.
Okay. And you mentioned that in your first contention also that it encourages a focus on all cases. Can you give me an example in which plea bargaining a plea bargaining of a certain case allowed for focusing on a different case?
Yes, in the examples that I brought up with the Wisconsin courts focusing on cases that were less pressing than those involving nonviolent crimes, it allows them to free up time and resources to increase the efficiency of the criminal justice system.
Okay, you stated at one point that that allowing for plea bargaining would allow for courts that cannot be trial due to the kind of evidence that would not be required, or the fact that the defense addressments would be ludicrous.
Yes, yeah, I brought up that example in the first part of my second mention.
So do you believe that a vital recourse and use of plea bargaining is that we can address trials in which we do not have sufficient evidence to prosecute?
Well, in this case, we would have to extend evidence, the search for evidence, and as I was speaking about in my rebuttal, having these cases addressed by a jury would almost be a better use so that we don't incur the exoneree problem that you were talking about in your third.
And is that currently how plea bargaining is conducted, or a possible reform that you are advocating for?
Well, it's a possible route that the United States could take. It's a viable solution.
Okay. And you mentioned in your second contention the how they are proportionally addressed. Can you specifically how El Paso has a sentence reassessment? Can you evaluate how they determined whether or not something was a proportional or not?
Again, when these cases are okay, what do you mean by that question?
Well, you stated that El Paso had a sentence reassessment
Oh, yes.
with recess sentence.
Yes.
How do they determine if it's proportional or not?
So they use a judge and a jury system to determine if it's important, and that is if the defendant feels that they have been disenfranchised in their experience with the plea bargain.
Okay, and that is all of my time for questions.
All right.
Okay, just for a brief wrap-up, I will be beginning my affirmative rebuttal where I focus on attacking my opponent's case. Judge, ready? Opponent ready? Yes. Then I shall begin. My opponent used the value of security. The problem with this is my opponent asserts that if we get rid of plea bargaining, the security of the United States, the security of our criminal justice system, and its ability to protect its capability to protect our citizens will be impaired. However, I negate this. The affirmative has shown that not only does the plea bargaining violate the values in which the criminal justice system is meant to protect, in which it keeps citizens from being jailed, it keeps citizens from being able, prevents people from being able to receive harsher punishments or lighter punishments that they do with the crimes that they committed. But in this case, we are impairing the security because we're impairing people's ability to believe that their security will be protected. We are impairing people's security from actually being protected. We are allowing innocents to be be indicted and be charged with these crimes that they've not committed as a result of plea bargaining. I'll address this more in a moment when I get to my opponent's contentions. My opponent uses the criterion of pragmatism. Similarly, with security, pragmatism is essentially my opponent asserts that pragmatism is maintaining the viability and feasibility of our criminal justice system to protect its citizens. Now, in the same way security is meant to protect the capability of our citizens, these values are essentially the same. Now, when we're talking about pragmatism, we're talking about, my opponent essentially states when we're talking about efficiency. Now, I negate the assumption that if we abolish plea bargaining system, we will necessarily see a decrease in efficiency. Now, my opponent's first contention, they mentioned this detriment to efficiency, stating that with the abolishment of plea bargaining, the Bronx shows that we will receive this backlog, and with the abolishment of plea bargaining, the South California Law Institute showed that they'll have an increase in judiciary usage. However, this, in both these cases, my opponent asserted was only with the abolishment of plea bargaining, no replacement. Now, to quote Tina Wen from the University of Southern California School of Law, the Supreme Court has never seriously considered any alternatives to plea bargaining other than providing a full-scale jury trial. But we've seen systems such as a jury waiver trial or a bench trial, or each of these two systems would allow for our efficiency to be maintained without the pitfalls that result as a result of plea bargaining, because they're allowing more rights to be maintained, because we're not putting people in this coercive bargain with their prosecutors and so on and so forth. My opponent also asserts that we're encouraging a focus on different cases, specifically with those consent courts. But the issue with deciding what cases we should focus on is we are saying that some cases are worth less than others. We're saying that some cases are morally deserving less of our time than others. And the affirmative negates the solution, because when we're talking about what is determined, we're talking about keeping proportions punishment. Now, the crux of the matter is that every case should proceed to at least a public hearing. Now, this could be with jury waiver systems or bench trials, or an alternative to plea bargaining with allowing people to maintain their rights till we can ensure that these pitfalls that we're seeing with the lack of respect due to the enclosed system. My opponent asserts in their second contention that the benefits outweigh the positives, but my opponent asserts the benefits deal with caseload, which again I've already addressed, and the keeping things proportionate. But the thing is that when we're talking about plea bargaining, it isn't proportionate. The El Paso system is not a universal system. We're talking about plea bargaining on the national scale. Now, my opponent asserts that we can have reforms, we can make it proportional, we can make these things happen. But Judge, we haven't seen reform up to this point. So if we haven't seen reform, then it means two things. Either reform isn't needed or reform isn't possible. Since I have shown shows with the affirmative case that reform is needed because we have these issues of people being acquitted. We have these issues of creating a solve the case prosecutor culture. We have these issues of people not respecting the justice system, receiving too light or too heavy sentences under plea bargaining. Then obviously we see that reform is needed. And since we haven't seen this reform up to this point, the entirety of we've been using the plea bargaining system, then obviously reform isn't possible, or no one is going to take it unless we do some alternative route. And it's for these reasons that we should cast affirmative ballot, and that is